invite the Attorney General of Guyana, the Honorable Mohabir Anil Nandlall, to address the court. Sir, you have the floor.
Mr. President, members of the court, it is an honor to appear before you and a privilege to deliver this final presentation on behalf of my country, the Cooperative Republic of Guyana. It is difficult to express in words how important this case is to Guyana and its people. As the court knows, this hearing is the culmination of a process which has been decades in the making. For more than 60 years, Venezuela has laid claim to more than 70% of Guyana's sovereign territory. Generations of Guyanese, mine being one of them, have grown up under the long and threatening shadow cast by Venezuela's claim to nearly 3/4 of our country. Venezuela's claim has blighted, bedeviled, and burdened Guyana for the entirety of its life as a sovereign state. It is hard to overstate the impact that this has had on Guyana's development, and on the security, prosperity, and well-being of its people. As our representatives vividly described on Monday, the loss of the territory claimed by Venezuela would eviscerate Guyana. Indeed, the country as we know it would cease to exist. Guyana's foreign minister was not exaggerating when he described this case as having an existential quality for Guyana. For Guyana and its people, the stakes could scarcely be higher. But while the stakes of this dispute could not be higher, nor could Guyana's faith in international law as the means for fairly and finally resolving it. As Attorney General of Guyana, I can personally attest to Guyana's profound commitment to the rule of international law. It is a commitment which runs deep in Guyana's institutions and national culture. It is both an article of faith and a source of national pride. It is founded on a firm conviction that international law is the bedrock of the international order and the indispensable foundation for peaceful relations between all states. From Guyana's perspective, there is no higher value or greater imperative than respect for international law. Mr. President, when Guyana brought its application to the court in 2018, it was confident of three things. First, Guyana had unwavering confidence in the correctness of its decision regarding the validity of the 1899 award and the boundary which it determined. Second, Guyana was equally confident in the wisdom of the decision of the Secretary General of the United Nations that the court should be entrusted with resolving this intractable controversy. Third, Guyana had complete confidence in the independence and impartiality of the court and its ability to deliver a just outcome based on a fair-minded and even-handed application of international law. Since Guyana filed its application 8 years ago, these proceedings have vindicated and reinforced Guyana's confidence in each of those things. At every stage, the court has conducted the proceedings with conspicuous care, attentiveness, and fairness. The court has carefully considered and confirmed its jurisdiction to entertain Guyana's application. And it has carefully considered and confirmed the admissibility of that application. We have no doubt that the court will now proceed to carefully consider the merits of Guyana's case regarding the validity of the 1899 award and the location of the parties' land boundary. Since the start of these proceedings, Venezuela has strained every sinew to avoid the court delivering a judgment on the merits of Guyana's application. These strenuous efforts have even continued throughout this hearing on the merits. Notwithstanding this court's judgment in 2020 and 2023, Venezuela has sought to argue that the terms of the Geneva Agreement mean that the court cannot or should not rule upon the validity of the 1899 award. Guyana's counsel have demonstrated the lack of merit in those arguments, which find no support in the text or the history of the Geneva Agreement, and which are contradicted by Venezuela's previous statements to the court, and so clearly by the pellucid terms of the court's previous judgments on jurisdiction and admissibility. It is not hard to see why Venezuela is so reluctant for the court to determine the merits of Guyana's application. Venezuela knows that it has no good answer to Guyana's case, and it knows that a judgment on the merits should bring to an end Venezuela's claims to almost 160,000 square kilometers of Guyana's territory. In its written and oral pleadings, Guyana has convincingly demonstrated that Venezuela's attempt to impugn the validity of the 1897 Treaty of Washington has no merit whatsoever. Venezuela was neither deceived nor coerced into signing the treaty. On the contrary, the treaty achieved what for years Venezuela had desired and demanded: the submission of its boundary dispute with Great Britain to international arbitration. Guyana has similarly and axiomatically demonstrated that Venezuela's attack on the validity of the 1899 award itself is misconceived. Neither the absence of written reasons nor the timing of the award's delivery calls into question its validity. The arbitral tribunal faithfully fulfilled the mandate conferred by the 1897 treaty. Neither the terms of the award nor the way it was reached involved any excess of power or impropriety by the eminent members of the tribunal. What is more, Guyana has shown that when the award was delivered in 1899, Venezuela was aware of all the matters which it now alleges vitiated the award. Yet, for more than 60 years after 1899, Venezuela respected, asserted, and affirmed the validity of the award. As Guyana has shown at this hearing, Venezuela has no credible answer to any of this. In short, the award was and remains valid and binding on the parties. In the words of the 1897 treaty, the award constitutes the full, perfect, and final settlement of the boundary between Venezuela and Guyana. At this juncture, I feel impelled to say a brief word about one of Venezuela's arguments which struck a particularly discordant note in Guyanese ears. As Professor Sands explained earlier, Venezuela's attempt to invoke the law of decolonization to support its case is legally unfounded. But it is also ironic because Venezuela's sudden repudiation of the 1899 award in the 1960s, just as the process of Guyana's decolonization was underway, impeded and delayed Guyana's progress towards independence by several years. And in the years since Guyana attained independence in 1966, Venezuela has acted in a way that has striking echoes of the imperial colonialists whom it rightly denounces. As Guyana has explained, both in its written and oral pleadings, since 1966, Venezuela has repeatedly denied and violated Guyana's sovereignty over its Essequibo region. Venezuela has invaded and illegally occupied Guyana's territory on Ankoko Islands for 6 decades. It has conducted numerous other military incursions into Guyana's land and maritime territory, incursions which are intended to menace and intimidate Guyana and its people. During the pendency of these proceedings, And in contumacious defiance of this court's provisional measures orders, Venezuela has enacted legislation which purports to incorporate our Essequibo region as a new Venezuelan state, to subject it to the jurisdiction of Venezuela's legislative, executive, and judicial organs, and to depict in official maps as an integral part of Venezuela. Venezuela has also sought to rename the territory as Guyana Essequiba. It has even falsely claimed at this hearing that the Essequibo River was named after a Spanish explorer. The name of the Essequibo River is in fact derived from an indigenous word, Dishikibo, meaning fireside, which was later adopted by the Dutch and the British. Venezuela's attempts to annex its smaller neighbor's territory, its attempts to erase and rewrite the history of Guyana's Essequibo region, and its innumerable bellicose threats to Guyana's sovereignty and territorial integrity are all redolent of colonialism. Mr. President and members of the court, the judgment that you deliver in this case will be of exceptional importance to Guyana. It is not simply the outcome of the judgment that will be important. The terms of the judgment will be equally crucial. If the court accepts Guyana's arguments, as we are confident that it will, then it is essential that the court's judgment directly, explicitly, and unambiguously affirms the validity of the 1899 award in its integrity and the boundary which it established, and elucidates the ineluctable legal consequences which flow therefrom. Any ambiguity or qualification in the court's judgment will inevitably be seized upon by Venezuela as a basis for continuing to lay vast swaths of Guyana's sovereign territory, lay claim to vast swaths of Guyana's sovereign territory. The clarity and specificity of your judgment are vital to the effective resolution of this long-standing dispute. You will have heard, as we did, the suggestion that a judgment in favor of Guyana would not end the dispute. That suggestion underscores the need for a clear and complete judgment. Mr. President and members of the court, thank you very much indeed for your patient attention, and I now request respectfully that you invite our agent, Mr. Carl Greenidge, to the podium to read Guyana's submissions. I thank you once again.